Well, good morning and good afternoon, good evening, depending on your time zone. This is an introduction to law and the Ethiopian legal system course. So here we will be considering the introduction to the course itself. So the course is Introduction to Law and the Ethiopian Legal System, which is provided in the Ethiopian Public Service University at the School of Law. I think no need to go to the details of the course, but this is the first year, second semester course, and it is with 3 credit hours and 5 ECTS, and I'm assigned as instructor to the course for this semester. Coming to the course overview, in general, the course will provide students with basic foundational knowledge on law in general. The course focuses on the nature of law in general, basic feature of law, sources of law, the making and the repeal of laws, hierarchy, interpretation and classification of laws. It also introduces the modern legal systems of the world in general, and familiarize with the Ethiopian legal system in particular. To this end, it will first consider the legal framework in Ethiopia, discussing common features of the African legal custom in general and the Ethiopian legal brief in particular. Concepts like legal pluralism and legal transplantation will be introduced. We will also consider legal history in general and legal history particularly from the Ethiopian legal point of view. This part will also consider one of the issues of interest in federal systems, that is the hierarchical relationship between federal and state laws. So obviously, legal frameworks need institutions to implement the laws under various jurisdictions. Therefore, the course shall present on the federal and the regional state institutional setups, their respective roles and powers, the administration of justice in Ethiopia and problems associated with it shall also be examined. Finally, the course introduces major dispute resolution mechanisms applied outside the court. This part is intended to provide a general conception of alternative dispute resolution procedures. More attention shall be laid on examining customary dispute resolution mechanisms in Ethiopia and their interplay with formal mechanisms. Therefore, when we come to the first chapter of the course, the first chapter has to do with the nature and functions of law. So this chapter explores the meaning and functions of law. It also examines the definition of law from different theoretical points of view. It also deals with the basic features of law. In addition, it investigates basic theories of law, including the natural law theory, positive law theory, Marxist law theory, and the realist theory of law. Further, it investigates the functions of law and examines the relationship between law and state. Finally, it considers the difference between legal norms and non-legal norms. You know that in the society we do find legal norms, that means norms that are provided by the sovereign state, and non-legal norms that are established and developed by the community on the communities themselves. Therefore, we will be considering those issues as well. Coming to the second chapter, which is about the sources of law. It deals with the meaning of source of law first. Next, it considers the material sources of law and it examines theories regarding mechanisms of transforming of custom into law. Further, it considers Christianity as material source of law and investigates the formal sources of law, including the role of court decisions as sources of Ethiopian laws. Particularly, the cassation decisions here in Ethiopia may be considered as sources of law. Otherwise, other decisions that are made by the courts might not be used as sources of law. Chapter 3 is about classification of laws. Under this chapter, the classification of laws in general is treated. Then, classification of law into public and private law is considered, which is followed by the classification of laws into international and national law. Finally, the classification of laws into substantive and adjective is investigated. Here we will be considering family law, for example, as substantive law, whereas civil procedure law as adjective law. Then the next chapter is chapter 4, which is about the making and repeal of laws. So under this chapter, we'll be considering the two essential points, the making and repeal of laws. Therefore, the chapter examines steps in making of law, which is followed by a comparative study of law, making process in Ethiopia previously and in the existing legal system of Ethiopia. Next, it examines the general concept of repeal of laws, the types of repeal of laws, and finally, we'll be considering effects of repeal of laws. Then, coming to chapter 5, which is devoted to consider hierarchy of laws, we will consider the general issues related to hierarchy of laws. Next, we will consider the supremacy of the Constitution by investigating the substantive as well as formal reasons. There are substantive reasons as well as formal reasons for supremacy of the Constitution. So we will consider them in detail under this chapter. Then finally, the chapter considers a comparative study of hierarchy of laws in Ethiopia. Then we will consider the topic under chapter 6, which is about interpretation of laws. So under this chapter, the general concept of interpretation of laws are considered. First and next types of interpretation are examined, and finally the chapter addresses the rules or techniques of statutory interpretation. Particularly under here chapter, we will be having the opportunity to consider or to study how the Ethiopian courts in general, and particularly the cassation division of the Federal Supreme Court of Ethiopia interprets laws, taking into account their interpretation. Chapter 7 is devoted to examine the definition and importance of juridical acts, and this will be followed by the examination of rules common to all types of juridical acts, because there are a number of rules that are applicable to all types of juridical acts. So we will consider them, and finally, under this chapter, we will investigate the effects of juridical acts. Basically, the effects of juridical acts is to bind those persons who have given their consent to be bound by their own consent, so long as the consent are given freely. Then coming to chapter 8, which is about the introduction to major legal systems in the world, we will be considering important legal systems in the world. Therefore, it compares the Anglo-American legal system with the civil law legal system after we consider the definition of legal system in general. Further, we will evaluate the merits and demerits of case law and statutory systems under this chapter 8. Then the first part of this introduction to law in general will be wind here, and we will consider the second part, which is devoted to the Ethiopian legal system. Therefore, under chapter 9, we'll consider the legal frameworks in Ethiopia in general. Therefore, this chapter provides the survey of common features in African legal system in general and their tradition. Then it investigates the legal pluralism and legal transplantation, evaluating the pros and cons. Further, we'll be considering the laws and practices in Ethiopia in general, and this will be followed by examination of the federal legal system, laws and practices. In addition, we will be considering the laws of the regional states. Furthermore, under this chapter, we will examine the conflict between federal laws and regional laws and what solution would be given in such a case. Finally, we will investigate the conflict between formal norms and unofficial norms. There are times at which we find the conflict between official norms and customary norms or unofficial norms. Therefore, basically, we will consider what solution would be given in such cases. Then, Chapter 10 is devoted to discuss the institutional frameworks in Ethiopia. Therefore, we will consider the federal institutions and their responsibilities under this chapter. We will also investigate the lawmaking, executive, and judicial organs. Further, we will evaluate the relationship between the federal and regional institutions. We will also consider the conflict between federal and regional powers. And finally, we will consider the administration of justice in Ethiopia under this chapter. Then the final chapter is about customary coexistent mechanisms of dispute resolution in general. So we will consider that under this chapter, and we will consider the concept of alternative dispute resolution, and we will also consider the customary coexisting mechanisms of dispute settlement in Ethiopia. And finally, we will examine the conflict between the formal and customary dispute resolution mechanisms. Finally, we do have resources for the course. The first important resource is the material written by Tesfaye Abate, Introduction to Law and the Ethiopian Legal System, teaching material, prepared under the sponsorship of the Justice and Legal System Research Institute. And there are also various books that are available, so you can visit the website as well. Students, we shall wind up this introductory chapter and wish you all the best. Thank you so much.